right now, we would like to join in this conversation Dr. Jeremy Levitt. He is a law professor at Florida A&M University College of Law, and of course, our Rise News contributor, Randall Pinkston, who has a law degree, is with us as well. Dr. Levitt, it's good to see you. Thank you for taking some time with us. So the prosecutor took about 30 minutes with their opening statement. The defense took nearly 3 hours with their opening statement. What were your impressions of their performances?
Well, I think the prosecution hit the nail on the head. The prosecution was concise and to the point. They made a very clear and convincing and compassionate argument. And when you looked at the courtroom, you saw various people there, not just the parents of Trayvon Martin, but other people in the audience there in the court tearing up, which means that they touched the minds and the souls of the people listening, including the jurors, and that's critical for the prosecution. I think the defense absolutely dropped the ball. Don West was clumsy and lackluster. He told a joke that bombed. It was insulting and uncomfortable, I think, for the jury, which is why he apologized after the break. This is a situation where you're making a joke in a homicide case, which is unheard of. I've never heard of anything like that. And I think at least before the break, after probably an hour's worth of testimony, one could say that he was rather patronizing, almost like he was speaking down to the jury. The notion that Trayvon Martin viciously attacked Zimmerman seemed to be a benchmark of his attempt at kind of a bumbling argument, and it just didn't work. It was horrible. I feel bad, and I think that the defense is in a big hole going into tomorrow.
Dr. Levitt, some observers have said that while the prosecution definitely came on strong right out of the box, and the tears in the courtroom, an indication of how he connected with the audience and perhaps with the jurors, but they also observed that during the prosecution's presentation, the jurors were not taking many notes, whereas during the defense attorney's presentation, opening argument, some of them were writing furiously. What do you make of that?
Well, you can look at this in a variety of different ways. What I would say is I think the prosecution's case was so straightforward and logical and rational that you don't need to really take notes for it. I mean, the narrative that he laid out, I think, was so basic that any person could sit and listen to it and play it back in their own mind. The problem with the defense was that he mentioned, Don West mentioned about 10 or 11 different names. The first, in fact, the entire day, the court sustained every objection of the prosecution except for one. He just wasn't convincing. And I think what they wanted to do, because he was bumbling so much, was to take very detailed notes so that they can go back and keep track of what actually was said. But the prosecution case, it was just very clear. It didn't require a lot of afterthought.
The time notwithstanding, I found it so interesting that the defense brought in props in their opening statement. That seemed unusual to me. Was that effective? Does that normally happen?
Well, I think what they were trying to do is lay down a time frame and give you a sense of the geography of the crime. And it can be very useful to do that in an opening argument. But I think it was too much. A 3-hour opening argument with tables and charts and dozens of names and a bumbling attorney doesn't help very much. I didn't think it was useful in this case. I think if they would have used maybe slides, it would have been better. The charts they used weren't very big, and the jury is probably 10 or so feet away. It just was not a good plan or strategy.
I wonder how important it is to form this rapport for the prosecution and the defense with the jurors, to make that connection right away. And does that last throughout the course of the trial?
Yeah, I think it does. I mean, the jury are regular people, and they're looking for a reason to be convinced. Obviously, the burden of proof lays on the prosecution. But even if you compare the two lawyers, it's very clear that Josh Guy and West are two different looking men. Their introductions were very different. One was very smooth. Guy is a very handsome presenter. He's a skilled litigator. And then you kind of have this almost bumbling professor trying to show you his various charts. It just didn't look well. And I'm not sure why Mark O'Mara allowed him to do the opener. He is a very well-respected attorney in the state of Florida, but today he was not on his A game.
You know, at the end of the defense attorney's opening argument, he did make what appeared to me to be a pretty powerful, perhaps provocative comment when he said that he has heard that Trayvon Martin was unarmed, and then went on to say that statement is untrue. Trayvon Martin armed himself with a concrete sidewalk. Pretty stunning statement to wrap up the opening argument, would you say, sir?
I mean, I think you're right in pointing that out, but I have to tell you, I was so unconvinced by hearing that. The notion that a child with an iced tea in one hand and Skittles in another turns into a monster and uses the sidewalk to bash somebody's head, it's just not realistic. And listen, the other thing that they did is they tried to make it seem like Trayvon Martin was a mixed martial arts master. When the reality was, it was Zimmerman who had been training in mixed martial arts for the past year and a half. And at the end of the day, it seems to me that he provoked a conflict and got the worst of it. And in an attempt to make his point stronger, he killed Trayvon Martin. I don't think that this is a complex case in terms of what actually happened, but it's up to the prosecution to prove it, and the defense will take every measure they can to cast that doubt.
You know, it was so interesting. The very first witness that the prosecution called, Jeremy, was Trayvon Martin's young friend, Chad Joseph. I wonder what your take is on the effectiveness of his testimony. One thing that I observed was he just looked like a young kid.
Because
and I'm sure that's
13,
what the prosecution wanted to think. He looks like an innocent young kid. Trayvon Martin should be perceived as an innocent young kid. What's your take, Jeremy?
I think you're exactly right. I mean, he comes up in a polo shirt that's buttoned all the way to the top, and basically said, listen, we played video games and watched television. He was very intelligent. He was very well-mannered. He responded to every question in a very timely way. And if this is a representation of Trayvon Martin, how could you possibly believe that he was the monster that the defense wants to make him out to be?
And you also would have to take note of the fact that Trayvon went to the store to get the Skittles for this young man.
Yes.
And that, if nothing else, it paints a gentle picture, a caring, compassionate, big brother kind of a picture of Trayvon for the jury.
Exactly right. In fact, someone who could be his little brother, right? Because Trayvon Martin was older, and the boy's mother was the girlfriend, and may still be, of Trayvon Martin's father, Tracy. So, he's going to the store to get his little brother something. I mean, that's just. I think it was extremely wise. I think all of the prosecution witnesses were quite good for the prosecution.
All right, Jeremy Levitt, thank you so much for taking some time with us. We do appreciate it.
My pleasure.
Stay with us as our special coverage of the killing of Trayvon Martin, the trial of George Zimmerman, continues.